Hello, I'm Adam Birnbaum. I'm an eviction attorney in Pierce County, and I've been asked by the Pierce County Law Library to make this presentation regarding removing trespassers or squatters and ejecting occupants. This presentation is regarding those situations where you have someone in your residential property who is not a tenant by definition, meaning that they have never paid rent to you, they don't have any type of signed rent or lease agreement, and basically are either strangers to you or do not have any rights of a tenant. Let's look a little bit closer as to what all that means. So with regard to trespassers or squatters, RCW 98.52.105 was passed. It's been several years now. That statute was enacted in response to basically emboldened transients breaking into unoccupied homes. There was a period of time when there was lots of vacant homes essentially on the market due to foreclosures. This was back in about 2008, 2009. And as those unoccupied homes were going through foreclosure or being marketed for sale, sometimes actually being rehabbed in between renters, they were being targeted for occupancy by transients. Law enforcement at the time didn't have a defined statutory basis for taking any action. And so the policy at the time for law enforcement was to tell homeowners that basically, hey, it's a civil matter. You need to hire an attorney to regain possession. So this statute was passed and allows the removal of an unauthorized person. And essentially, subject to subsections 2 and 3, and upon receipt of a declaration, which we're going to go over in just a moment, the owner of the property can summon law enforcement to the property, provide them with a copy of the declaration, and that would be sufficient basis for the officer to remove the occupant as a trespasser. Here's a copy of that declaration. Let's take a moment and go through exactly what certified statements need to be made. And this form will be available at the law library. You need to go ahead and indicate the location of the property on the upper line. And then you're stating under declaration of penalty of perjury that you are in fact the owner of the property or the authorized agent of the owner of the property, that an unauthorized person or persons have entered and are remaining unlawfully on the premises, that the person or persons were not authorized to enter or remain, that the persons are not a tenant or tenants and have not been a tenant or tenants, or a homeowner who has been on the title within the last 12 months on the property, that you as the declarant have demanded these unauthorized persons to vacate, but they have not done so, that the premises was not abandoned at the time that the unauthorized persons entered, that the premises was not open to members of the public at the time the unauthorized person entered, and that you as a declarant understand that a person removed from the premises based upon using this declaration, if any false statements have been made, that you may be held liable for actual damages, costs, or reasonable attorney fees. So again, this is with regard to trespassers. And so what we're talking about is a stranger, someone that is unknown to you that has come into occupancy of your property. Typically, what law enforcement is going to require in order for you to use this form is that there is a sign of breaking and entering into the property. So before calling law enforcement, you're going to want to determine whether or not a window's been broken out, if a door's been kicked in, or how it is that the occupant got into the premises. If you don't find a means that the tenant has, that the occupant has entered into the property, I would encourage you to still fill out the declaration, contact law enforcement, and see if they can assist. But the probability is going to be higher that they're going to take action if there actually is a sign of breaking and entering. So if it's a situation where you had a tenant in the property and on their way out, for example, they passed their key to their buddy and their buddy just moved right in, this probably is not going to work as far as a means of getting rid of that particular person, even though they're technically a trespasser. Another means of getting repossession of your residential real property when you're not dealing with the tenant is an ejectment action. Ejectment actions are used to regain possession when the occupant does not meet the definition of a tenant and is not a criminal trespasser. Typical situation for an ejectment action is where the occupant is known to the owner. This is typically a situation where you have a family member or a friend that has moved into the property, typically with permission of the property owner, and is now refusing to leave. And again, this deals with a separate property, not a situation where a property owner has allowed someone to come in and share a room in their primary residence, but if they have a separate premises all to their own. This also includes situations where even though there may be a lease, that the relationship between the owner and the tenant does not come under landlord-tenant under the Residential Landlord-Tenant Act. This would be in the case of an employee that may be renting from you, but are required to live on site as part of their job requirement. The purpose of ejecting someone is to allow someone who has title to the property to regain possession from anyone and everyone who does not have a better claim of occupancy. This comes through common law and also through statutory authority, RCW 7.28.010. And if we take a quick look here, a portion of that statute basically cites the common law, which says any person having a valid subsisting interest in real property and a right to the possession thereof may recover the same by action in the Superior Court of the proper county to be brought against the tenant in possession. Ejectment actions are civil actions. So unlike an eviction action or an unlawful detainer action, they require a civil summons that gets served upon the occupant together with a complaint, and the defendant then has 20 days to respond. There's no statutory requirement like in an eviction action. You start directly with the lawsuit. And if your occupant does respond to the complaint, then you need to continue and file a summary judgment motion with the courts in order to get the relief that you're seeking, which is a writ of ejectment. Once the writ of ejectment is approved by the court, you will need to get an indemnity bond for the sheriff before the sheriff will serve that writ of ejectment. So I hope that clarifies somewhat the two procedures you can use when a eviction action under the Residential Landlord-Tenant Act does not apply. Again, that would be using a trespass notice where you contact law enforcement directly, or filing a civil action known as an ejectment action to get rid of those occupants who have entered the premises with permission of the owner. Further information and forms will be available through the Pierce County Law Library. Please feel free to contact them or contact me if you have any further questions. Thank you.